Hello zusammen and welcome back to the channel. This is going to be one of the more important videos because this deals directly with human rights law and deals directly with a Supreme Court of a foreign country that ruled that parts of the sex offender registry are unconstitutional. Now, before I begin the explanation of what happened in the Canadian Supreme Court, let me give some background. The background is this. You know, because I've put out a video on it and you've seen it, that governments love to take horrific incidents with children and turn those horrific incidents into an excuse to pile more registration requirements on to those who've committed sex-related offenses. A couple examples. In Florida, we had the Jimmy Rice Act, where this kid, I think he was a 9-year-old boy, was kidnapped, raped, murdered, raped again, and then dismembered. However, when the legislature used his case as an excuse to pile on restrictions onto those who've been convicted of any crime, they ignored the kidnapping, they ignored the murder and focused only on the sex offenses. And therefore, we had the first civil commitment law in Florida. Nationally, we had the Jacob Wetterling Act, where this young man, I don't remember his age, he was kidnapped, raped, and murdered. But the legislature, in this case the Congress, ignored the kidnapping, ignored the murder, and focused only on the sex offense. Jessica Lunsford, she was kidnapped, raped, and murdered. But the Florida legislature ignored the kidnapping, ignored the murder, and focused only on the fact that she was sexually assaulted. Then, of course, we have probably the most famous law at this point, the Adam Walsh Child Protection Act, named after Adam Walsh, who was kidnapped and murdered. There's actually no evidence, there's, as far as I know, nothing to suggest that he was actually sexually assaulted. However, ignore the kidnapping, ignore the murder, let's focus on this possible sex offense that they've used to really beef up the sex offender registrations across the United States. The legislatures never want to focus on, let's create a registry for those who've kidnapped children, and they don't have a registry for those who've murdered children. They're only focused on the sex offenses. That is clearly what the puritanical Congress and state legislatures are focusing on. That being the case, the craziness that's been going on in the United States with the sex offender registries has, of course, rolled across the border into Canada. In, I don't know what year, but there was an 11-year-old boy by the name of Christopher who was, you got it, kidnapped, raped, and murdered. And the Canadian Parliament ignored the kidnapping, ignored the murder, and focused only on the fact that he was sexually assaulted. And they enacted a law in 2000 called Christopher's Law, which set forth the first Sex Offender Information Registration Act. I'm going to pronounce it as SORA, creating a sex offender registry in Canada. The law went into effect in 2004. In the first version of the law that was put into effect in 2004, the registration requirements were not mandatory. It was actually up to the discretion of the sentencing court to determine if this particular defendant was such a threat to the community that he needed to be put on a registry, and for how long. However, Parliament wasn't satisfied with that, so in 2011 they came on and they amended the law. They took away the discretionary power of the judge and made registration mandatory and lifetime. Those were two particular provisions put into the Canadian law. Those are the two provisions that were ultimately taken to the Canadian Supreme Court. So after this law was beefed up, a gentleman whose name I simply cannot pronounce, and I apologize if I'm offending him or his family. I looked up his name online on several websites to try to figure out how to pronounce it. The only thing I can find out is that his name is of African origin, and there has been no pronunciation posted online. I don't want to butcher his name, so maybe I'll just put it here at the bottom of the screen, and you can do your best. I certainly did my best. Nonetheless, this gentleman was 19 years old and was at a party, got drunk, and acted inappropriately with two young ladies. Ultimately, the court determined that he really was not a danger to the community, did not need to be put on a registry, that this was an isolated incident in his life, and that he just wasn't such a danger that these additional requirements needed to be put on him. Therefore, The judge went against it. However, after the legislature beefed up this sex offender registry, the SORA, it was now made mandatory on this gentleman, and it was made lifetime. He challenged it to the Canadian Supreme Court. Of course, it had to go through several steps to get there, but that's where it ended up. And the Canadian Supreme Court basically said that these two provisions, the mandatory and the lifetime registration, those two provisions are unconstitutional because they are so broad that they encompass every person convicted of a sex-related offense, even if that person really isn't a danger to the community. And that's one of the things that we've been arguing for a long time, is the problem we have in the United States and now progressing into other countries is that all sex offenders or all sex offenses are lumped into one category. And the 19-year-old young man who has a 16-year-old girlfriend is classified as a sex offender on the same level as someone who kidnaps a 9-year-old child, rapes them, murders them, cuts them up into pieces, and hides the body pieces around a plantation. That was the Jimmy Rice case. And so they're lumped together as though they're somehow uniform, and as though all sex offenders are created equal, and that's absolutely absurd. Further, there's the whole issue that there's no evidence that these registries actually work. What the government doesn't want you to know is that the majority of sex offenders who fall into the category of they had an underage girlfriend or boyfriend, the majority who fall into that category do not go on to reoffend. They actually have among the lowest rates of recidivism, but the legislatures just don't want you to know that. That doesn't fit their political agenda. And so the Canadian Supreme Court actually recognized those things, that there is a difference between the 19-year-old young man with his 16-year-old boyfriend or girlfriend and the person who, raped a child, kidnapped them, and murdered them. They're not the same. They should not be treated the same. Therefore, to take the discretion away from the court violates the Canadian Constitution. So let me be very clear. That is what the Canadian Supreme Court said in this decision. It did not find that the registration was unconstitutional, merely the fact that it was mandatory and that it was lifelong. And the Canadian Supreme Court gave discretion back to the court. As I close up, let me point out that in Florida, where I come from, it is the same. The law is mandatory and it is lifelong. So it's very interesting to me that the Canadian Supreme Court has found those two particular things to be human rights violations, to be unconstitutional. I wonder how that'll play into the Florida courts. It'd be fun to see, because that is something that I work on daily. So I hope this information was good for you. I hope it was entertaining. I hope it was informative. But I always say, if you're not happy with your situation, do something about it. And this young man in Canada did something about it. And look what he was able to do. So until next time, my friends, be smart and be safe. From Southern Germany, cheers.